Hello everyone, welcome back to the channel EduTap. I am Advocate Arshdeep Kaur, and as you already know that SEBI Grade A Legal exam notification is out. We have already completed the SEBI Act and today we will be starting with the Securities Contract Regulation Act 1956. The security laws are very important. They have been given 40% weightage in the examination. So you need to start preparing for these from now only. Before I start, I would like to tell you that EduTap has come up with a live crash course for phase 1 and phase 2 of this examination. It is going to be very important for anyone who is applying for the post. We will be having more than 60 live sessions, 2 hours each, so it will be very helpful to you. In addition to this, EduTap is also coming up with a test series for both the phases, phase 1 and phase 2. It will help you a lot in the revision. We are running a limited time period discount, so if you want to avail it, kindly refer to the link in the description below. Let's start with the lecture now. Question number 1. Which of the following is not a participant of stock market? The options are stock exchange, clearing members, demat account, depository or broker. The answer to this is option C. Option C, demat account. Demat account is also known as dematerialized account, is not a stock market participant. It is just a tool which helps trading in stock market, right? It is just a tool and it is not a participant in the stock market, right? A demat account. What is a demat account? Demat accounts help investors hold shares and securities in an electronic format. It also helps to keep proper track of all the investment an individual makes in shares, exchange traded funds, bonds, mutual funds in one place, right? So demat account is an account that stores all the financial assets of an investor, right? Question number 2. Which of the following are not true regarding the Securities Contract Regulation Act? It has total 32 sections. Under this act, most powers with central government can also be exercised by SEBI. This act aims to prevent undesirable transaction in securities. It came into force in the year 1959 or none of the above. The answer is option D. Option D is the incorrect option. It came into force in 1956. All the rest options, they are correct. They are factually true. We can read them again. These are all the true statements. It has total 32 sections. So we know that this act has how many sections? 32 sections. Under this act, most powers with the central government can also be exercised by who? SEBI. This act aims to prevent undesirable transaction in securities. It so says in the preamble. It came into force in the year 1959. No, it came into force in the year 1956. So this is the incorrect option, right? Now we can move on to question number 3. Which of the below are incorrect information related to depository? NSDL and CSDL are the only depositories in India. NSDL and CSDL have designated various depository participants on its behalf. Depository participants open demat account of investors. Depository participants can be banks or the brokers itself. The answer is option E, none of the above, which means all these statements are true. Right? So all the options are correct. So the answer is E. Because the question was we had to take out what? We had to take out the incorrect option. That is, none of this is incorrect. All of them are correct. That is why the option is E. Let's read them again because these are all the true statements, right? So NSDL and CSDL are the only depositories in India, correct? NSDL and CSDL have designated various depository participants on its behalf. This is also true. Depository participants open demat account of investors. Right again. Depository participants can be bank or the brokers itself. Right. So all of these are correct. Now question number 4. Every application for recognition of the stock exchange shall be accompanied by all the following documents details except which one? Which documents details will be accompanied by the application? Let's find out. The options are the governing body of such stock exchange, its constitution and powers of management and the manner in which its business is to be transacted. qualification to become members of stock exchange and the suspension, exclusion or readmission to the stock exchange, the powers and the duties of the office bearers of the stock exchange, the copy of the bylaws of the stock exchange for the regulation and control of contracts, none of the above. The answer is E, none of the above. So all these have to be accompanied by the application for the recognition, right? So all of these are required to be accompanied by the application of the recognition of any stock exchange. Let's read the explanation. Section 3 of the Act. Any stock exchange which is desirous of being recognized for the purpose of this Act may make an application in the prescribed manner to the central government. They have to make the application to the central government under Section 3. The central government. Every application under subsection 1 shall contain such particulars as may be prescribed and shall be accompanied by, first, a copy of the bylaws of the stock exchange for the regulation and the control. A copy of the bylaws. Bylaws for what? For the regulation and the control of the contracts, and also a copy of the rules relating in general to the constitution. So in general relating to the constitution of the stock exchange, right? And in particular, it will also accompany the governing body of such stock exchange, its constitution and powers of management, and the manner in which its business is to be transacted, right? The powers and the duties of the office bearers of the stock exchange, the admission into the stock exchange of various classes of members, the qualifications for membership, and the exclusion, suspension, expulsion and readmission of the members therefrom or thereinto, right? And the last is the procedure for the registration of partnership as members of the stock exchange in cases where the rules provide for such membership, and the nomination and appointment of authorized representatives and clerks. So A to D, all of these are mentioned in section 3. That is why the answer is option number E, none of the above. All of these shall be accompanied with the application. Shall means it is mandatory. So none of the above, option E. Right? So now next question, question number 5. How many persons represent the central government on each of the stock exchange? Okay. The answer is maximum 3. That is option C. Let's read the section first. Subsection 2. The conditions which the central government may prescribe under clause A of subsection 1 for the grant of recognition to the stock exchange may include, among other matters, condition relating to, first, the qualifications of the membership of stock exchanges, the manner in which the contract shall be entered into and enforced as between the members, third, the representation of the central government on each of the stock exchange by such number of persons not exceeding 3, as the central government may nominate in this behalf. So how many members? Maximum 3 members. Fourth, the maintenance of accounts of members and their audit by chartered accountants whenever such audit is required by the central government. Right? So how many representatives? 3. Maximum 3. Not exceeding 3, maximum 3. I hope this is clear. So maximum 3 persons represent the central government on each of the stock exchange. Right? Now question number 6. Under which section of the Securities Contract Regulation Act 1956 the central government can delegate all the powers to SEBI? Okay. The answer to this is section 29A. Let's read this section. The central government may, by order published in the official gazette, direct that the powers, except the powers under section 30. Except the powers under section 30. So this means that section 30 is the exception to section 29A, right? The central government may by order published in the official gazette direct that the powers except the powers under section 30 exercisable by it under any provision of this act shall in relation to such matters and subject to such conditions, such matters as the central government may think and such conditions, with such conditions. So, such matters and subject to such conditions, if any, as may be specified in the order, be exercisable also by the Securities and Exchange Board of India or the Reserve Bank of India constituted under Section 3 of the Reserve Bank of India Act 1934. Right? It can delegate its powers to SEBI and the RBI. Right? It can delegate the powers to SEBI and RBI. Section 30 is an exception to this section which deals with the powers of central government to make rules. So that means all the powers can be delegated except Section 30. And Section 30 deals with the power of the central government to make rules. So clear? That means that Section 30 is the exception to Section 29A, and the central government can delegate the power to the SEBI and the RBI except for Section 30, which deals with the powers of the central government to make rules. Right? Let's move on to question number 7. For any reasons or in situation of emergency, central government can ask the stock exchange to suspend its business for a period of not more than 5 days, 7 days, 10 days, 15 days or 21 days. The answer is 7 days. Option B. Section 12 deals with the power to suspend business of recognized stock exchange. If in the opinion of the central government an emergency has arisen and for the purpose of meeting the emergency, the central government considers it expedient so to do, it may by notification in the official gazette. How it will suspend? By notification in the official gazette for reasons to be set out therein. The reasons have to be mentioned. Direct a recognized stock exchange to suspend such of its business for such period not exceeding 7 days. For not exceeding how many days? 7 days, which means maximum of 7 days. So not exceeding 7 days and subject to such conditions as may be specified in the notification with specified conditions, if any. And if in the opinion of the central government the interest of the trade or the public interest requires that the period should be extended, and supposingly that the central government thinks that in public interest this period of 7 days is to be extended, may by like notification, similar notification again, extend the said period from time to time, provided there is a proviso that where the period of suspension is to be extended beyond the first period. Beyond the first period means beyond the 7 days period. No notification extending the period of suspension shall be issued unless the governing body of the recognized stock exchange has been given an opportunity of being heard in the matter. Unless the governing opportunity has been given a reasonable opportunity of being heard, it cannot be extended after 7 days, right? The opportunity has to be given, right? So the answer was 7 days. Option B. Next question. Question number 8. As per Section 21A of the Securities Contract Regulation Act 1956, which of the following may delist the securities? So who has the power to delist the securities? The answer is option C, the stock exchange itself. Let's read Section 21A. A recognized stock exchange may delist the securities after recording the reasons therefor from any recognized stock exchange on any of the ground or grounds as may be prescribed under this Act. So on the grounds as may be prescribed under this Act after recording the reasons. Provided that the securities of a company shall not be delisted unless the company concerned has been given a reasonable opportunity of being heard. The company has to be given a reasonable opportunity of being heard. A listed company or an aggrieved investor may file an appeal before the Securities Appellate Tribunal against the decision of the recognized stock exchange delisting the securities within 50 days. This is also very important. That the appeal lies where? SAT, before the SAT, and it has to be filed within 15 days. Within 15 days from the date of the decision of the recognized stock exchange to delist it. Right? Let's read it again. A listed company or an aggrieved investor may file an appeal before the Securities Appellate Tribunal against the decision of the recognized stock exchange delisting the securities within 15 days from the date of the decision of the recognized stock exchange delisting the securities, and the provisions of Section 22B to 22E of the Act shall apply as far as may be to such appeals. there is a proviso again, provided that the Securities Appellate Tribunal may, if it is satisfied that the company was prevented by sufficient cause from filing an appeal within the said period, allow it to be filed within a further period not exceeding 1 month. So a period of 1 month can again given, but only if the SAT is satisfied that they were actually prevented to file appeal by a sufficient cause. Then only it can be given a further period of 1 month, right? 1 month. Within 15 days they have to file it, and then it can be extended to 1 month. So the answer is option C, stock exchange. Stock exchange can delist the securities under section 21A and its appeal lies to the SAT, right? Now question number 9. The Securities Contract Act 1956 aims at which of the following? Giving the central government the power to regulate stock exchanges and clearing corporations through a process of recognition and continued supervision, regulating listing and delisting of securities on stock exchanges, regulating contracts in securities, preventing undesirable transaction in securities, all of the above. Answer is E, all of the above. The Securities Contract Act 1956 aims to prevent undesirable transaction in securities. As I've told you, this is written in the preamble. It gives the central government the regulatory jurisdiction over. It gives the central government the jurisdiction over stock exchanges and clearing corporation through a process of recognition and continued supervision. Contracts in securities, listing and delisting of securities on stock exchanges, right? So answer is option E. We can move on to the next question, question number 10. If one deals in securities designated as illegal or prohibited securities under Securities Contract Regulation Act 1956, then such person is punishable with. Answer is option C, imprisonment for a term which may extend to 10 years or with fine which may extend to 25 crore rupees or both. Either only imprisonment or only fine or both, right? If one deals in securities designated as illegal or prohibited securities under the Securities Contract Regulation Act 1956, then such person is punishable with imprisonment for a term which may extend to 10 years. Which may extend to 10 years means maximum of 10 years imprisonment, or with fine which may extend to 25 crore rupees or both. Maximum fine could be 25 and maximum fine could be 25 crores and the maximum imprisonment can be 10 years, or he can be punished with both, right? Question number 11. Any person aggrieved by any decision or order of the Securities Appellate Tribunal may file an appeal to which of the following authority? So where does an appeal of the order of SAT lies? It lies in the Supreme Court, right? Answer is option E, Supreme Court. If we read section 22F, it makes it clear. Any person aggrieved by any decision or order of the Securities Appellate Tribunal may file an appeal to the Supreme Court. May file an appeal to the Supreme Court within 60 days. Within how many days? 60 days. From the date of communication of the order. From the date of the communication of the order or order to the Securities Appellate Tribunal to him on any question of law. Or if he has asked any question of law from that order, then from that day. Out of such order, provided that the Supreme Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed not exceeding 60 days. So he can then again be given 60 days period. The original time is also 60 days. It can also be extended to 60 days again if the Supreme Court is of the opinion that yes, he was prevented by a sufficient ground. So the answer is option E, Supreme Court. Next question. As per section 23J of the Securities Contract Regulation Act 1956, which of the following factors to be taken into account while adjudicating the quantum of penalty? Quantum of penalty, this I have already told you, it comes later on. This means that he has been proven guilty. He is guilty and now his quantum of penalty has to be decided, right? So which of these have to be taken in account? We'll read the options first. The amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of the default. The amount of loss caused to an investor or group of investors as a result of the default. The repetitive nature of the default, A and C only, all of the above. Answer is all of the above. All of these have to be taken in account while adjudicating the quantum of the penalty, right? If we read the section, these are the factors to be taken in consideration. The amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of the default. The amount of loss caused to an investor or group of investors as a result of the default. The repetitive nature of the default, right? So all of these have to be taken into account. Clear? Let's move on to the next question now. Question number 13. Section 7 of the Securities Contract Regulation Act 1956 deals with which of the following? So which of these deals with section 7? So section 7 deals with what? Section 7 deals with annual reports to be furnished to the central government by the stock exchanges, right? Let's read the section also. Every recognized stock exchange shall furnish the central government with a copy of the annual report, and such annual reports shall contain such particulars as may be prescribed. So the answer is option E. Annual reports to be furnished to the central government by the stock exchange. Question number 14. Which of the following section of the Securities Contract Regulation Act 1956 is related to the power of stock exchange to make bylaws? Answer is option B, section 9. Section 9 of the Securities Contract Regulation Act 1956 provides for the power of stock exchange to make bylaws. Which section? Section 9. Question number 15. As per section 16 of the Security Contract Regulation Act 1956, which of the following has the power to prohibit contracts to prevent undesirable speculation in specified securities? The answer is C, the central government. So who has this power? It lies with the central government. Power to prohibit contracts in certain cases. If the central government is of the opinion that it is necessary to prevent undesirable speculation in specified securities in any state or area, it may, by notification in the official gazette, in any state or in any area, declare that no person in the state or area specified in the notification shall, save with the permission of the central government, save with the permission of the central government. It can take the permission from the central government. Enter into any contract for the sale or purchase of any security specified in the notification except to the extent and in the manner, if any, specified therein. Right? Clause 2. All contracts in contravention of the provisions of subsection 1 entered into after the date of notification issued thereunder shall be illegal. They will be considered illegal. Right? So the answer was option C, the central government. The central government has the power to prohibit contracts to prevent undesirable speculations in specified securities. Right? This is a bonus question. This is going to be your homework. I'll read the question. As per Securities Contract Regulation Act 1956, securities include which of the following? So, what all is included in securities? So, this is your homework. Kindly comment down the answer below. So, that's all for today. I hope it was a helpful session for you. For more such videos, please subscribe to the channel EduTap. Thank you.